Good morning, everyone.
Good morning, ma'am.
So, how are you today? So, wait. Before we start, let me check your attendance first. Where is Mr. Okay, 1, 2, 3, oh. Mas kasing care natin dyan, Miss Sinsuat. Hindi pa ba tapos yung pa-gym natin, John? Okay, so I think everyone is around, I think. So, are you ready for our class today?
Yes, ma'am.
Yes, ma'am.
So, para maiba naman today, let's start our class with a game.
Magdulat ata, ma'am.
So, we will play Bring Me. So, if you have the item with you, show it to the class, and I will give you 10 points for that. For example, sabihin ko, bring me a lipstick. So, ito, show nyo sa class like this. Oh, bakit ayaw mag-focus? Sira na ata. Okay, whatever. So, show it to the class. Ma'am, I have with me a Verbilena matte lipstick with a circle, with the EB and everything. So, just describe to the class.
Yes, ma'am.
And then, I'll give you 10 points for that. So, let's start. So, first, bring me, ito, nagkakaubusan na nito sa ball. So, swerte na lang kung meron pa kayo nito ngayon. Alcohol.
Here, ma'am, I have with me casino ethyl
Very good,
alcohol.
Miss Chu. You'll have 10 points for that. Okay, our second item. Okay, madali lang din to. Nakikita to sa kusina. Ketchup.
Ma'am, I have with me Del Monte ketchup.
Bakit parang si Miss Chu lang
Naago ko'y kayo.
ang nandito? Sana yung iba. Keep up, guys, ha? Keep up. 10 points to, remember? Okay, third item.
Late ka, girl.
Ay, sorry. Miss Jenny, late ka na. For our third item, we have... Ano ba? Bring me a food seasoning.
Ma'am, ako. Meron akong...
Okay, very good,
Maggi
Miss
magic
Sinsuat. You have
syrup.
10 points for that. So, lastly, last item natin to. Keep up, guys, ha? Galingan nyo naman. Last item na to. Nakikita to sa kusina. So, get ready. Bring me a soy sauce.
Here, ma'am, I have the Silver Swan soy sauce.
Very good, Mr. Torculas. Ang bilis mo naman. May toyo ka na agad dyan. Okay, so from that, did you enjoy it?
Enjoy na
Yes,
lang,
ma'am.
ma'am.
Okay. Can you guess what's our topic for today from that game?
Ay, ma'am, kinatay, toyo,
For sure
ketchup,
na-
ug
alam niyo
alcohol.
na,
Sure na dyan ko
dyan
sa
sa
pambahaton karon,
syllabus.
ma'am. Himo tagtambal para sa COVID-19, ma'am, no?
What? Bro, Miss Peñamante, ano? Tambal sa COVID-19. Ha? Wait. Na-high blood. Na-stress ko. Wait lang. Nabuang ko, day. Patakara juga, day. Okay. Siya, tambal sa COVID. Okay. Any volunteer?
Ako, ma'am, ako.
Taro nga, ha? Na-stress ko ba? Kasama ba? Okay. Ako na yung manawag. Kasama ba? Quiet, please. Okay. Okay, Miss Andamon.
I guess our lesson
What's your
for
answer?
today is trademark, ma'am.
Ay, my gosh. Tama, Miss Andamon. Correct. Our topic for today is trademark. Naano na sa inyong syllabus? My gosh. Okay. Trademark tong topic ha. Dili tambal sa COVID-19. Na-stress. Na-high blood ko, Miss Peñamante. Okay. So, our topic for today is trademark. So, what is trademark? Today, we are going to discuss an interesting topic in intellectual property law. Basically, the intellectual property law has three main components. We have copyright, trademark, and patent. And today, we are going to discuss about trademark. Trademark can be found everywhere. It can be found in your basic needs, such as the food you eat, your beauty essentials, perfumes, or even the services you enjoy. Trademark can be a distinguishing sign, like a word, phrase, symbol, or a combination of those. Essentially, trademark is any visible sign capable of distinguishing the goods or services of an enterprise, and shall include a stamp or mark container of goods. Further, trademark indicates the source or origin of the goods on which it is used, so that it would not cause public confusion. Importantly, take note that the purpose of trademark is well illustrated in its four functions, namely, economic function, in which trademark serves as an essential means of distinguishing the products of one manufacturer or dealers from those of the others. Second, source indicating function, wherein trademarks indicate the source or origin of the goods on which it is used. Its immediate object is to distinguish the goods of one manufacturer from those of his competitors. Third, guarantee function, in which trademark serves to guarantee that the product to which it is affixed comes up to a certain standard of quality. And lastly, advertisement function. The more widely advertised the product is, the more readily may courts concede that it has become distinctive of its proprietor's goods. Importantly, intellectual property rights are a legal form of protection that give you the ability to stop others from making, using, selling, or importing your product or creations. And essentially, for one to enjoy the rights over a trademark, he must first register it in accordance with the provisions of the intellectual property law. So now that you already know the basic concepts of trademark, we will now further go into details. And now, we will have a surprise recitation. Bantag na napoy ma-disconnect dira, kay ambot lang anong inyong connection mawala pag na-recitation.
Mag-recite pala tayo, ma'am. Pero you did not announce it yesterday, ma'am.
Kaya nga surprise.
Now I have with me your class cards. So first,
Yes, ma'am.
Miss Andamon, how can a trademark be acquired?
Acquisition of trademark. Section 122 of the Intellectual Property Code provides that the rights in a mark shall be acquired through registration. However, if the mark consists of immoral, deceptive, or scandalous matter, or is identical with a registered mark belonging to a different proprietor, or is likely to mislead the public, then the mark cannot be registered. You can read Section 123 for the entire list of unregisterable marks. If yours is not among those, then you can proceed to filing the trademark application form. Just fill up all the necessary information, attach a drawing of your mark, submit all the documents, and pay the fees at the cashier. Remember, however, that you have to submit a declaration that you're actually using the mark and attach some evidence proving the same. Your certificate of registration, once granted, shall be valid for 10 years, renewable for periods of 10 years at its expiration. One more thing. Under the Trademark Law, only the owner of the trademark, trade name, or service mark is entitled to register the same. In other words, the right to register a trademark is based on ownership. So if the applicant is not the owner of the trademark, then he has no right to apply for the registration. To illustrate, in the case of Superior Commercial Enterprises versus Kunan Enterprises, Supreme Court held that Superior, as a mere local distributor and not the owner, had no right to the registration of the disputed trademark. An exclusive distributor does not acquire any proprietary interest in the principal's trademark and cannot register it in his own name. To sum it up, a registered trademark protects a business's brand identity in the marketplace. Hence, registration gives the owner the exclusive rights to prevent others from using or exploiting the mark in any way.
Thank you, Miss Andamon. Miss Chu, what are the limitations in the use of trademark?
The limitations on the use of trade name or business name are:
Today's topic are the limitations on the use of trade name and business name. 1. A person may not use a name if the word is generic, as held in the case of Lyceum of the Philippines versus the Court of Appeals. Here, there can be no exclusive use of the word Lyceum. In fact, educational institutions of the Roman Catholic Church used the word Lyceum long before appellants started using it. 2. A person may not use any name indicating a geographical locations, as held in the case of Ang Si Heng versus Wellington Department Store. A person may not use any name or designation contrary to public order or morals. 3. A person may not use a name if it is liable to deceive trade circles or the public as to the nature of the enterprise identified by that name, as provided under Section 165.1 of the Intellectual Property Code. 5. A person may not subsequently use a trade name likely to mislead the public as a third party. 6. A person may not copy or simulate the name of any domestic product or a mark registered in accordance with the provisions of the Intellectual Property Code, and use a mark or trade name calculated to induce the public to believe that the article is manufactured in the Philippines or that it is manufactured in any foreign country or locality other than the country. Additional rule provided under Section 166 applies to imported products or to those imported articles shall not be admitted to the entry at any custom house of the Philippines, and any change in the ownership of the trade name is made with the transfer of the enterprise or part thereof identified by that name.
Very good, Miss True. Mr. Torculas and Ms. Peñamante, can you explain to the class the two tests in determining confusing similarity?
Over the years, the Supreme Court has fashioned two tests to determine whether a mark infringes another. First is a dominancy test. The dominancy test focuses on the similarity of the prevalent or dominant features of the competing trademarks that might cause confusion, mistake, and deception in the mind of the purchasing public. It relies on visual comparisons between two trademarks. Furthermore, duplication or imitation is not necessary. Neither is it required that the mark sought to be registered suggests an effort to imitate. Given more consideration are the oral and visual impressions created by the marks on the buyers of goods. This test is applied in the case of McDonald's versus LC Big Mac Incorporated. This case involved a trademark infringement lawsuit filed by McDonald's Corporation against LC Big Mac Incorporated, a domestic corporation that operates fast food outlets and snack vans that sell hamburgers and other food items. It uses the mark Big Mac, and in this case, the Supreme Court applied the dominancy test and found a likelihood of confusion between the Big Mac and McDonald's Big Mac. Here, the Supreme Court held that there is trademark infringement, giving the following reasons. In short, orally, the two marks are the same, with the first word of both marks phonetically the same, and the second word of both marks also phonetically the same. And visually, the two marks have both 2 words and 6 letters, with the first word of both marks having the same letters, and the second word having the same first 2 letters. In spelling, considering the Filipino language, even the last letters of both marks are the same, and applying the dominancy test, the Supreme Court held LC Big Mac liable for trademark infringement. Further, in the case of Nestle versus Court of Appeals, here, Nestle is a Swiss corporation which uses the marks Master Roast and Master Blend for their coffee and coffee extracts. They opposed CFC Corporation's registration of Flavor Master for their instant coffee. The Supreme Court ruled here in Nestle's favor because the word master was a dominant feature of Nestle's mark. From the evidence at hand, it is sufficiently established that the word master is a dominant feature of a poster's mark. And further, The master has always been given emphasis in the TV and radio commercials and other advertisements made in promoting the product. Thus, applying the dominancy test, the court found that there was trademark infringement. Also in this case, the tribunal explicitly junked the holistic test in favor of the dominancy test. Now, what is holistic test?
Holistic test. As defined with the Philippine jurisprudence, holistic test, which is also known as totality test, means a consideration of the entirety of the marks as applied to the products, including the labels and packaging. In determining confusing similarity, the discerning eye of the observer must focus not only on the predominant words but also on the other features appearing on both labels so that the observer may draw a conclusion on whether one is confusingly similar to the other. Dominancy test versus holistic test. In the case of Philips versus Philips, GR number 1868, the Supreme Court laid down the main distinctions between the two tests. This case is of special significance because the Supreme Court used both the dominancy and holistic test in determining the likelihood of confusion between the competing marks. Brief facts in this case. The case started when Philips filed a trademark application for the mark Philips for the goods fluorescent bulb, incandescent lights, tartar, ballast in Class 11. On the other hand, respondent Philips Electronics opposed said application, arguing that the registration of the trademark Philips and letter P device will violate its rights as the registrant of the well-known mark Philips. Thus, the Supreme Court of the Philippines, in resolving the issues in this case, used the two tests in determining the similarity and likelihood of confusion. This is the trademark of Philips and Philips. The Supreme Court, applying the dominancy test, observed that the dominant feature is the five-letter component of the competing marks PHILI, which is Philips for respondent and Philips for petitioner. The Supreme Court said that this dominant feature visually catches the attention of the consuming public who does not have the luxury of time to ruminate the phonetic sounds of the trademarks to find out which one has a short or long vowel sound. The Supreme Court further pointed out that petitioner and respondent are engaged in the same line of business and that both marks are used in the same goods, which are light bulbs. On the other hand, in applying the holistic test, the Supreme Court examined the entirety of the marks as applied in the products, including the way the goods are packaged. The Supreme Court noted that the Philips trademark that petitioner actually seeks to register is vastly different from the trademark that it actually uses in the container and packaging of its light bulb products. The Supreme Court compared petitioner's Philips trademark shown in the container and packaging of its light bulb products with the respondent's Philips trademarks as used in the wrapper or packaging of its products, and thus, the Supreme Court concluded that there is a strong similitude and likeness between the two trademarks. The Supreme Court in this case, did not grant the registration of Philips for their trademarks because of the said similarity. Thus, in conclusion, the difference between dominancy test versus holistic test is that dominancy test focuses on the similarity of the dominant or prevalent features of the trademark. On the other hand, the holistic test considers all aspects of the said mark. And that would be all, ma'am, and thank you for your time and thank you for listening.
Excellent, very good. Thank you. Ms. Sinsuat, what is trademark infringement?
The use without consent of the trademark owner of any reproduction, counterfeit, copy, or colorable imitation of any registered mark or trade name. A crucial issue in any trademark infringement case is the likelihood of confusion, mistake, or deceit as to the identity, source, or origin of the goods or identity of the business as a consequence of using a certain mark. The elements of trademark infringement are as follows. First is the validity of the mark. Second, the plaintiff's ownership of the mark. And third is the use of the mark or its colorable imitation by the alleged infringer results in likelihood of confusion. Failure to present proof of actual confusion does not negate a claim of trademark infringement. While proof of actual confusion is the best evidence, its absence is actually inconsequential. Now, once it can be established that there is trademark infringement, what are the remedies of the trademark owner against the infringer? So the remedies of the trademark owner may either be civil, criminal, or administrative. As to the civil remedy, this one is filed with the regional trial courts. The owner of the registered mark may ask the court to issue a preliminary injunction to quickly prevent the infringer from causing damage to his business. Furthermore, the court will require infringer to pay damages to the owner of the mark, provided that he is shown to have had notice of the registration of the mark, which is presumed if a letter R within a circle is appended, and stop him permanently from using the mark. As to the criminal remedy, the owner of the trademark may ask the court to issue a search warrant, and in appropriate cases, remedies available shall also include the seizure, forfeiture, and destruction of the infringing goods and of any materials and implements, the predominant use of which has been in the commission of the offense. As to the administrative remedy, this one can be availed of by the trademark owner if the amount of damages claimed is not less than 200,000 pesos. The registrant may choose to seek redress against the infringer by filing an administrative action against the infringer with the Bureau of Legal Affairs. In the case of Republic Gas vs. Petron, the mere unauthorized use of a container bearing a registered trademark in connection with the sale, distribution, or advertising of goods that will cause confusion is already considered as trademark infringement.
Thank you, Ms. Sinsuat. Ms. Alapan, what is unfair competition?
Hello everyone. What is unfair competition? So this is provided under Section 168.2. It defines as employing deception or any other means contrary to good faith by which a person passes off his goods or business or services for those of one who has already established goodwill thereto. So this is illustrated in the case of Republic Gas Corporation versus Petron Corporation, that this is a passes off or palming off or attempting to pass off upon the public goods or business of one person as the goods or business of another with the end and probable effect of deceiving the public. So, a distinction should be made between suits for trademark infringement and unfair competition. So, the former is unauthorized use of trademark, whereas the latter is a passes off of one goods as those of another. Fraudulent intent is unnecessary in the former, while it is essential in the latter. And lastly, in the former, prior registration of trademark is a prerequisite to the action, while it is not necessary in the latter. So it can be noted here that there can be unfair competition and infringement at the same time. So, in the case of McDonald's Corporation versus LC Big Mac Burger Incorporated, it cited the following essential elements of an action for unfair competition. So, first, confusionally similar in the general appearance of the goods, and lastly, intent to deceive the public and defraud the competitor. So, it also enunciated in the case of Superior Enterprises Incorporated versus Conan Enterprises, the following true tests of unfair competition whether the acts of defendant have the intent of deceiving or are calculated to deceive the ordinary buyer making his purchases under the ordinary conditions of the particular trade to which the controversy relates. So, in order to prove a case of unfair competition, it is sufficient to show that the deception will be natural and probable cause of defendant acts. That's all. Thank you.
Very good, Miss Alapan. So I think that is all for today. I hope you learned a lot. See you soon. Keep safe. Goodbye.